on a motion from witness Maurice Hall. Mr. Hall, could you spell your names? We've gotten different spellings on your name.
The correct spelling for you guys will be Morrishall.
All right. And representing Mr. Hall today, note your appearances.
Good morning, Your Honor. Adrian Cousins and Jeffrey Eisman on behalf of Mr. Hall.
And Mr. Hall, your attorneys are present. When they address the court, they're going to go to the podium, so you should be able to see them at that time. But obviously we are not in a position where you can consult privately with them today, but you've had a chance to talk to them. Is that correct? That's a yes?
Yes.
All right, thank you. All right, this is Mr. Hall's motion as a witness to quash the subpoena. Who would like to address it? Ms. Cousins, if you would. And you can take off your mask if you'd like.
Thank you, Judge. Good morning, Your Honor.
Good morning.
Mr. Hall has been subpoenaed as a witness in this case by both the prosecution and defense. Defense counsel in their opening statement specifically named Mr. Hall and told the jury that they intend to call him and previewed what that testimony they believe would be. So in order to avoid any kind of delay or interruption in these proceedings, I notified all parties that Mr. Hall would be invoking his Fifth Amendment privilege against self-incrimination were he called to testify. I then subsequently filed my notice, my motion to quash the subpoena. Your Honor, at this point in time, Mr. Hall has no immunity. He has been provided no immunity, no protection for his testimony whatsoever. And because of that, Mr. Hall is invoking his Fifth Amendment privilege against self-incrimination in several key areas of questioning that we believe he would face were he to be called to testify.
Well, let's stop you there. You said on certain areas that he would testify to. So there are some topics that would not incriminate him. Is that correct?
Your Honor, I cannot envision any topics that Mr. Hall would be called to testify on that would be both relevant to the case that would not incriminate him.
Well, that's ultimately the court's decision, correct?
Yes.
Okay. And that's on a question-by-question basis. Is that correct?
Yes, Your Honor.
Okay. All right. Go ahead. I interrupted you.
No, that's okay, Judge. And just for brevity, I wanted to outline those areas that I believe Mr. Hall may face questioning. The first area where he would be invoking his privilege against self-incrimination is any activities that took place on May 25th, 2020, both before and after police arrived.
Okay.
Mr. Hall's testimony in these matters would specifically put him in the position of being in very close proximity to Mr. Floyd. There's an allegation here that Mr. Floyd ingested a controlled substance as police were removing him from the car. A car, by the way, that has been searched twice, and to my understanding, drugs have been found in that car twice. This leaves Mr. Hall potentially incriminating himself into a future prosecution for third-degree murder. And specifically, that's 609.195 subdivision B. And that statute, as the court is well aware, covers third-degree murder liability for someone who is involved in drug activity that eventually leads in an overdose. And that statute is broad, Judge. It does not just include the situation where A sells drugs to B, B then succumbs to an overdose. In fact, it includes any activity directly or indirectly, unlawfully selling, giving away, bartering, delivering, exchanging, distributing, or administering a controlled substance classified as Schedule 1 or 2. So that statute is broad, Judge, and it has been interpreted broadly by Minnesota courts. Again, it's not just that A and B situation. In fact, anyone who can be pointed to as a link in the chain of distribution, someone who prepares drugs for someone else, someone who acts as a go-between, can be implicated in third-degree murder. And so any of the activities that Mr. Hall would be testifying about throughout that day, and including before police arrived on May 25th, 2020, could potentially incriminate him in that charge, not to mention drug sale and drug use. Additionally, the other area of testimony in which Mr. Hall would be invoking his Fifth Amendment privilege is any personal knowledge that he has of drug use by George Floyd up until and including May 25th for the exact same reason, Judge. It leaves him open to exposure on a potential future third-degree murder charge. Any testimony regarding his activities with Mr. Floyd could leave him open to potentially incriminating himself.
Right. I think what I'm going to do is ask Mr. Nelson to list for the court the topics and areas and whether there's something outside of what you just outlined. So, because maybe there is some common ground there. So if you could just switch places.
Your Honor, it would be the defense intent to inquire of Mr. Hall as to the following. Certainly, any events leading up to Mr. Hall and Mr. Floyd's arrival at Cup Foods earlier in the day, where they were, what they were doing. Mr. Hall's interactions with Mr. Floyd in the Cup Foods, including whether either party gave the other a counterfeit bill. Whether or not Mr. Hall gave, sold, or otherwise provided Mr. Floyd with controlled substances. Specifically, whether Mr. Floyd, his behavior in the car, Mr. Hall previously described that Mr. Floyd was falling asleep, that it was sudden. I would ask him questions about Mr. Hall's previous statements to law enforcement that Mr. Floyd had indicated he did not intend to or that he was planning on taking these pills later when they got home, implying that Mr. Floyd took them before they left. Mr. Hall described seeing Mr. Floyd go for the ignition when the police arrived, so his behaviors in the car at the time police arrived. Mr. Hall, I would intend to ask him about giving false names to police officers after they were intervened, after the police intervened. Mr. Hall is seen on a security camera taking something out of his backpack and throwing it. I would ask him about those and what it was that he threw. And I would also ask Mr. Hall about his decision to leave Minnesota immediately after this incident and his subsequent apprehension by the Texas Rangers.
Well, let me focus on a couple things. I think you would agree that any questions that he answers about the counterfeit bill falls within could incriminate him. Would you agree with that?
Yes.
Also, the false information he gave to the police, he would have a legitimate invocation of his Fifth Amendment rights there as well.
Yes.
And what he took out of the backpack, that's a legitimate Fifth Amendment privilege to invoke there.
Yes.
Flight as circumstantial evidence of guilt, you would agree that his fleeing to Texas, if you went into motives, as opposed to simply traveling to Texas, that could be considered incriminating. Would you agree with that?
Yes.
The use and possession of drugs by both of them during that day, that could incriminate him based on counsel's representation. Would you agree with that?
Yes.
It seems like just about everything that you want to ask him, except the following. He would have a legitimate right to invoke his Fifth Amendment rights against compelled self-incrimination. And that being how George Floyd appeared when he was back in the car and the falling asleep suddenly. Would you?
Well, I mean, the
And I'm sure counsel is going to say that that's incriminating, but
I do not believe that in and of itself incriminates Mr. Hall in terms of a description of Mr. Floyd falling asleep. But the implication being that because fentanyl was found in Mr. Floyd's system, and it causes a person to fall asleep, that would be ostensibly connected to ingestion of controlled substances. So, I mean, remotely perhaps, I would argue, but not in and of itself.
all right. Ms. Cousins, would you? And unfortunately, you don't have the benefit of having sat through all the testimony, but it appears that this would be a proper invocation of his Fifth Amendment rights for just about everything Mr. Nelson was talking about. The one exception appears to be his observations sitting in the passenger seat of the car as how Mr. Floyd appeared, that he was falling asleep and that it happened suddenly. Very narrow. And the reason why I say that is because we have kind of a parallel testimony from a clerk in the store who said Mr. Floyd appeared good-natured, seemed to be having a good day, but he did appear to be high. I don't even think I'd allow counsel to ask whether he appeared high, because that could have formed some kind of opinion and infer a basis that he knew why he was under the influence. But it seems to me that just his description, Mr. Hall's description of, like the store clerk, is not going to incriminate him if there's no questioning about how he had, why he fell asleep, why he thinks he fell asleep, that there were drugs in the car, that he knew there were drugs in the car, that there was any possession by Mr. Floyd of drugs that day that he saw. If we totally avoid the word drugs and just have Mr. Hall say, I was the passenger in the car, which is already clear. There's video and evidence, just for your knowledge, that Mr. Hall is in the passenger seat and is removed by the police. Beyond that, if that were established that he was the passenger when the police came up to the car, what was Mr. Floyd's condition immediately that he observed immediately before that? Would you agree that that's not incriminating if we keep all the mention of drugs or why or anything like that?
No, Your Honor, I do not agree that
How
that
would
is not
that, when it did not incriminate the clerk who said he thought he was high, how would it be that Mr. Hall saying that would incriminate him?
Well, because first of all, Judge, the inquiry is not what evidence is in front of the jury. What testimony have they heard?
No, I'm just using that as an analogy on how that certainly didn't incriminate the store clerk by saying, well, he appeared high. Well, Mr. Hall saying, well, he appeared like he was falling asleep and it happened suddenly. Without anything else, seems to be a parallel type evidence. So I was using it as an analogy.
I understand, Judge, but the whole point here is to prevent Mr. Hall from incriminating himself. And him even answering that question that he was in the car puts him in very close proximity with Mr. Floyd, very close in time before he's alleged to have ingested drugs. And again, it exposes him on that third-degree murder charge. If there were to be a future third-degree murder charge, and Mr. Hall was charged with basically being involved in this drug activity that had caused Mr. Floyd to pass away due to an overdose, him even being in that car incriminates him in terms of behaviors of Mr. Floyd, what he observed when he observed it. So, no, Your Honor, I would argue that it definitely would expose him to potential incrimination.
Well,
not to mention, Judge, that this is a car where drugs have been found twice.
Well, and the state has all that evidence. That's pretty clear. And I know we're not talking about, but that didn't incriminate him. The video of him sitting next to George Floyd does not incriminate him, or has not subjected him to criminal liability, at least yet. So
And
you're
I think
saying
that's
beyond
the,
that
that's the key word, Judge, is yet.
yeah.
Is yet. The
But
question
you
is,
think his observations of how George Floyd looked would incriminate him? I
Absolutely.
don't see how that would put him closer to criminal liability just with those observations.
because it then takes the onus off of the state in any future prosecutions to prove what demeanors, behaviors, attitudes Mr. Floyd was exhibiting should they decide to charge Mr. Hall with the crime. Now they've got his own testimony to use against him. That's the very definition of a Fifth Amendment privilege, Judge.
Well, if it incriminates,
Yes,
just the fact that he testifies does not make it incriminating.
but his testimony would be used to incriminate him in a future prosecution.
Well, anyway, Mr. Frank, do you need to weigh in on this? I don't think you have a dog in the fight at this point.
Well, I do, Your Honor, and I would like to be heard briefly.
Sure.
Thank you, Your Honor. Our
You're
dog,
not going to represent his interests, are you?
I am not.
Okay,
Our dog in the fight is a fair trial for Mr. Chauvin,
of course.
and one trial. And what we can't have is an invocation of this privilege in front of the jury. And this questioning that the court is offering or suggesting creates a huge problem. And the reason why I cited the Caldwell case to the court is because this questioning would not exist in a vacuum. And we have to remember, too, that the standard is not just whether this evidence itself is inculpatory or implicates him. It's whether it creates a link. And I think that's partly what Ms.
Understood.
Cousins is referring to is it now puts him in that vehicle, and it's testimony from he himself creating the part of that link. And as I said, it won't exist in a vacuum. There would be other questioning, and we would have the right to question him about his credibility and other aspects of that interaction then that would lead, unfortunately and potentially, to him invoking question by question in front of the jury.
But we regularly, in fact, did in this case, in excruciating detail, walk through motions in limine, limiting what questions could be asked of various witnesses based on rules of evidence. This is not based on rules of evidence, it's based on his Fifth Amendment rights and what could possibly incriminate him. But limitations, and you gotta admit, as Mr. Isaacman and I can tell you, the Caldwell case is a totally different situation. That was a man who wanted to testify despite being warned that everything he said would incriminate himself and didn't care until he realized it might get him into more trouble than he thought. I think it's the complete opposite of this case.
It's an illustration, Your Honor, of how, despite that witness trying to tailor his evidence to meet a certain goal, it just couldn't be done. And it led to, and fortunately in that case, there wasn't a jury sitting there, but that invocation, that's where they ended up in that case. We can't have that when we're in front of a jury. And Mr. Hall would be faced with the question by question determination of what we're arguing about this morning. That's why sort of a blanket invocation is allowed because the standard is rather broad.
What case law says that there is such a thing as a blanket invocation of Fifth Amendment
I
rights?
can't cite the court a case that has yet
Well,
to
and
use
I'll
the
admit-
blanket invocation, but
And I'll admit, I don't think there's clear Minnesota case law on it, but I'm looking at Illinois, the Northern District of Illinois, Oregon, I think Hawaii as well. A couple of cases, just to take a look at Hillman versus City of Chicago, 918 F Sup 2nd 775, which is the Northern District of Illinois. Oregon versus Rodriguez, 301 Oregon Appellate 404. Shackman, Shakman versus Democratic Organization of Cook County, which is 920 F Sup 2nd 881. It's pretty clear from those cases, and granted they're not Minnesota, that the invocation of the Fifth Amendment right is on a question by question basis, and the legitimacy of that invocation is to be determined by the court, which makes sense. Otherwise, somebody who just didn't want to testify could say, I'm asserting my Fifth Amendment rights.
I agree with that concept, Your Honor. We cited the court a case where they talked about a voir dire process. And essentially, this hearing is a substitute for that process because we know from his counsel that he is going to invoke the Fifth Amendment about the very areas she discussed. And there just is no legitimate way. I mean, there isn't really any question that all of the matters that counsel identified and Mr. Nelson identified are tied intimately to his interactions with Mr. Floyd that day and in the previous weeks, and it ties him. So we're not facing a question like maybe perhaps in those cases where they might just be invoking because they don't want to testify. Here there is a legitimate link in the chain from what he's going to be asked about and quite a few potential crimes, not just the third-degree murder, obviously being the most important. I mean, we even know, we've talked about the sense of opposing counsel has suggested almost an alternative perpetrator. In that sense, with the third-degree murder, but there's also drug charges, counterfeiting, false information. And I don't know how we put on Mr. Hall to testify and ask him one question and then let him leave without having the ability to pursue, as we normally would in a trial, the credibility and the foundation for that testimony in light of all we know. So I think that this case doesn't raise the kinds of questions that maybe are being brought up in the cases the court cited. I'm sorry, I can't speak to them, personally right now, but here there's no question that the singular questions the court is inquiring about are intimately linked to George Floyd and the activities of that day, all the other areas that
Well, I think if you look at the case law, it's much closer to incriminating behavior like this Shackman case, it's really clear that I would have not ruled the way they did. I would have said that was a proper invocation, and they're like, no, it's not a problem.
Well, that's Illinois.
Yeah, let's do this step by step. I appreciate your argument, and I think I know where we're kind of heading with that. This is what I'm going to propose. We're not done today with this. I think we have pretty much established, or based on what Mr. Nelson has said, there's really a very small, narrow topic that might be permissible. So what I'm going to do is I'm going to ask Mr. Nelson essentially to draft his, in written question form with the expected answer based on whatever statements were made on what that would be. That way, Mr. Hall can meet with his lawyers and talk about would he be willing to answer those. Then we can have another hearing outside the hearing of the jury where we walk through and see if he would, number one, if I, based on my review of the examination, believe that it is a proper invocation of Fifth Amendment rights to that or not, question by question basis. And if I say it's not a proper invocation, is Mr. Hall willing to answer? Despite your ruling, Judge, he's still not going to? Well, he is subject to contempt then. But I think we get too far ahead when we kind of are being vague. Let's say, what are the questions we're going to ask him? Let's walk through outside the hearing of the jury whether or not I would allow it and find that it's not incriminating. And then based on that, Mr. Hall can meet with his lawyers. So I'm talking by Thursday. I'd like that list. The state can do any indication of cross. Same thing. I'm guessing what you would want to cross Mr. Hall on as far as his credibility and all that, well, it's pretty much up to you, Mr. Frank, but I think that might, since it might widen the net some, so to speak, some of yours might clearly get him into Fifth Amendment issues. But I think we need to, if Mr. Nelson can get you that, you can write up your own list of questions, and let's do it outside the hearing of the jury. And he has time to talk to his attorneys before we put him on the stand cold, and he has to confer with them one by one. So, and it's a limited, I'm only allowed for that, limited, and this isn't a final ruling, this is the only part that I think is possibly not subject to a Fifth Amendment claim. Tell me what you want to ask. We'll run it by outside the hearing of the jury on a question by question basis. The court will make a determination, and then counsel can follow up with Mr. Hall, and based on the court's ruling, are you going to testify? And we go from there. So I don't want this to be the last and try and push through a ruling when we need to tread carefully, obviously. Fifth Amendment right is a broad one, and I agree. The link, you have to worry about links to possible prosecution, but at the same time, if everything's linked, then it's a blanket prohibition, and that is not the case law. So with that, everybody's got their homework assignments. Let's go with that. All right?
Very well. Thank you, Ron.
But for now, do not waste your time on all the other stuff. It's that narrow, limited area that we're going to talk about. Okay?
Thank you.
It's 5 to 9. Let's see if we'll probably start up at 9:15 with the jury. All right, we're in recess. Thank you, Mr. Hall.
Thank you, Judge.
If Mr. Nelson can get us something Thursday, I'd like everybody else to maybe